Good morning. Welcome to the Pro Bono Partnership of Atlanta Immigration Compliance in an Era of Worksite Enforcement webinar. First, a couple of housekeeping rules. I will be taking questions. Please do type your questions out during the presentation, and I can address them then or at the end of the presentation. Quickly, I want to go over the mission of the Pro Bono Partnership of Atlanta. It's to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. Next slide. The Pro Bono Partnership of Atlanta Eligibility is available on their website. You can go to www.pbpatl.org and look at how you can become eligible to be served by the Pro Bono Partnership. Legal information really quickly. This webinar presents general guidelines for Georgia nonprofit organizations and is not to be construed as legal advice. Always consult your attorney to address your particular situation. And of course, this webinar is all the rights are reserved and can't be copied. They'll be available afterwards on the website. Let's start talking about immigration reform. And the first thing I want to address is the Immigration Reform and Control Act of '86, or IRCA. It's responsible for the Form I-9, the little pesky little Form I-9. And basically what IRCA does, it prohibits employers from knowingly hiring or continuing to employ people not authorized to work in the U.S. So it requires employers like yourself to verify a new employee's identity and authorization to work. Now, how do you do that? It's called the Form I-9. It used to be a one-page form. It's now really a 9-page form, but 2 pages have to be filled out by you as the employer. And the latest edition of this I-9 form is actually March 18, 2013. So please use that new form. Obviously, if you have former employees, they could use the old forms. You don't have to go in and re-verify everyone just because there's a new form. But keep in mind that the new form is 2 pages. It's the actual form itself on the website is 9 pages again, 2 pages of form, and then the last page, page 3, is the list of acceptable documents. Again, the form is available on the website, the USCIS website. Also, something else you may want to look at and download is the handbook for employers. It kind of looks like this. It's about 70 pages. It's also referred to as the M274 handbook for employers. And again, here's the website where it's available. Now let's talk about the I-9 a little bit in more detail. It's changed a little bit, and I want to kind of point to some of the things you need to be aware of. Section 1 is to be filled out by the employee. And again, there's some changes I highlighted here. Last name and first name fields. Other names used to be called maiden name. Sometimes that's just is not appropriate. There are no P.O. boxes anymore. You have to have a physical address. And now there's also an email address on there. Question I get a lot is, do I fill out my email address? You don't have to. Immigration says, well, if there's something missing, we can email you. Well, maybe so, but again, there's no absolute need to fill in that field. Same thing with the telephone number. But again, that's something that you. By the way, U.S. Social Security number, you don't have to give that to on the I-9, unless, of course, the employer is using E-Verify, because that is based on the Social Security number. So Section 1, again, that has to be completed on or before the first day of work by the employee. And the employee basically says, I'm authorized to work in the U.S. And that the documents I present to you, employer, are genuine and relate to me. They're not a fraudulent document. They're truly my documents. Then the attestation here in Section 1, a little different from the previous version. It has 4 blocks need to be filled out. Obviously, one of them needs to be filled out so you know who you're dealing with. A number, that's also referred to as alien registration number or USCIS number. Have to have foreign passport information on there. And then the signature box is more defined than in the previous version. You'll see signature of employee. And again, that's all employee driven. If in fact the employee is having someone help with filling out this application, either by translating or helping preparing, then a preparer or the translator needs to fill out that Section 1 certification. And again, there, just told you what some of the changes were in that Section 1 prepared box. And there's a stop sign at the end of that form, means that's it, employee, do not fill out anything else. Section 2 is for the employer. That is where you come in, person you designate at your company to be in charge of I-9. And again, here, this is on page 2 now. This used to be all on the same page. So make sure you fill out on the top of the page the employee's last name, first name, and middle initial, again, from Section 1. Because if at some point these forms become separated, page 1 and page 2 become separated, you can then maybe find out where it is and match them back up. List A, List B, List C, you'll see that. There are little changes in this new form with the captions, make it a little more clear. Keep in mind, again, it's a List A document or a List B and C document, not A, B, and C, or not any other combination. And we'll talk about a little more detail in a minute. Again, this is what the employer fills out, certifies that, in fact, he or she has looked at the documents that the employee has handed over and that they appear to relate to that person. I guess my advice would be whoever does that kind of work for you, the I-9 work, make sure they're detail-oriented, that they look at these things, that the names match, that the birth dates match, that in fact that person standing in front of you has the document that you have in your hand, that it belongs to them. Had a client once who had an issue with an I-9, old I-9, and he said, we can't understand, he gave us a green card. It appears to belong to him. It's his name. I got a copy of it down the road. The young man was about 25 years old. The birth date on the green card was 1943. So it obviously could not belong to him, and someone was asleep at the wheel when reviewing these documents. So important to have someone give great attention to detail. Again, as an employer, you fill this out on or before the third business day, the third work day, and you attest basically as the employer that I've verified these documents and that they're the originals, not copies. They appear to be genuine and not frauds. And to the best of my knowledge, as employer, I believe that this person is authorized to work in the U.S. That's your job as an employer. As I mentioned earlier, in Section 2, it's either List A, which is identity and authorization to work, or List B and C. And then look on page 9, the last page of your Form I-9, what documents are in these columns, List A column or B and C column. And again, what I would do is I would give the full 9 pages of the I-9 form to the employee before they fill it out so they can familiarize themselves with it, but also show them the last page. These are the documents I'll need, or one of the documents I'll need, or a combination of documents. Sometimes I've had clients say, well, the employee comes in and throws a bunch of documents on my desk and go ahead and pick. And then as an employee, you have to say, no, you give me a List A document or a B and C document. It's not up to the employer to pick a form or a document. And also, the employer cannot request a document. Can't say, well, where's your green card? Well, that's not necessarily something I need to give you. I can give you a Social Security number and a driver's license, and it'll be fine too. So that's the employer's job. Keep in mind, the documents you verify as an employer need to be the originals, no copies. I know sometimes that does present problems for folks who have multiple locations. And then, well, can I use a copy? No, you cannot. What you can do typically is you could tell someone to, you could deputize someone at that location saying, you review these documents, sign it off, and I give you authorization to do that. But you have to look at the actual documents, the true documents. But make sure that the same employer representative signs the form, the person that actually looked at the documents, not someone looking somewhere else, and then you can kind of rely on that and you sign it for them. Can't do that. It's got to be the same person. And Immigration and Customs Enforcement is very picky about that. Now, sometimes they ask you, what about documents must appear to be on their face to be genuine? What does that mean? I'm not a document fraud expert. I don't have a blue light in my office and kind of look at things. Just be reasonable. You know, you're not a document fraud expert. I'm not. Very few people are. Make sure that the biographic data match the employee standing in front of you. That's important. Check for consistent type style. The example I gave you earlier, apparently I didn't see the original document, but the original document had it was a green card and had been opened up, and a picture had been slipped in there. The actual young man's picture was slipped in there in front of his grandfather's picture. But again, the birthday didn't match. Obviously on the Social Security card, if things are scratched out or wired out, not good. You can always request the employee to bring another document in if you're not satisfied with the genuineness of the document. Don't fret too much. I mean, if it looks real, again, the M274 Handbook for Employers has examples of those. You know, if you really have a problem, you know, check with your HR supervisor or check with your attorney if you have an issue and think, wait a minute, is this a real Social Security number? Again, be reasonable, but make sure you have a great attention to detail. I want to talk briefly about the receipt rule. What if someone doesn't have a document and said, well, I have asked for a receipt. I've asked for a new document because I lost my driver's license and I'm replacing it, or I lost my work permit and I'm replacing it, and that's okay as long as they come in within 90 days with the new document. Where it's not okay is if someone comes in and said, well, you know, I'm married, I'm not a U.S. citizen, I'm married a U.S. citizen, and I'm getting a work permit because of that, and I've applied for it. Here's the receipt. That's not good enough because it's an initial work authorization, not a receipt for replacement, and that would not be good enough. You actually have to have the original employment authorization document, or EAD, or work permit. And also for an extension, it's not good enough. These work authorizations on List A, they expire, and you have to extend them. Crazy thing is, while you're extending them, you know, of course, if the old document's still valid, you're okay. But if it expires, you can't employ this person anymore until the new document actually has been received. So I tell folks, start early enough to file this extension. It takes about 90 days, so start about 120 days before, so that this person doesn't become, you know, at some point not work authorized, and you have to terminate them or at least suspend them for a while. Again, complicated rule, more complicated it needs to be, but it's there. Section 3, typically referred to as the reverification block. It's now referred to as Reverification Rehires. It's relabeled, some new fields on there, and again, just some formatting changes. That if someone comes in with a new document, and we'll talk about what those, when that could happen, but if someone comes in with a new document or an expired document and now they want to renew it, Section 3 is typically used for that. Or if it's a rehire, someone you've hired or you've had on your payroll in the last 3 years, you can fill out that form. Or, of course, you can fill out a new I-9 as well. Again, it's for people with temporary work authorization. I mentioned the work permit or employment authorization document. Keep in mind that if their document expires, monitor that expiration date. Have some kind of tickler system, because you have to go back in before their document expires and say, hey, it's time for you to bring me a new document. If not, then they become unauthorized employees, and you as the employer are liable if at some point Immigration and Customs Enforcement comes in and says, hey, I need an I-9 audit, and this person, their document's expired, but they're still on your payroll. That's a knowing violation, and the fines could get pretty high on that. What about copying? I get a lot of questions, and you probably hear a lot of folks talking about, well, should I copy these documents? You can. You don't have to. It's not required, but whatever you do, be consistent. And if you have copies, attach them to the I-9 form. My recommendation, that's just personal recommendation, do not copy, because it's a lot easier to be consistent. If you do copy, and for instance, your regular person is out, someone else is doing the work and forgot the copy, then you're not consistent anymore. What if the copying machine is broken, or the toner is low, and you can't make a copy, you forget. You're not being consistent, and that could be a paperwork violation, which typically has a fine of anywhere between $110 and $1,100 per instance, per I-9. What about the I-9s? How long do I keep them? Forever? No, don't keep them forever. Keep them for at least 3 years or 1 year after termination, whichever is longer. Obviously, you have to have I-9s for everyone that works there. But if these folks are gone, no need to keep them for 10 years after they left you. So if someone's been working with you for 5 years and they're terminated or leave, keep them for another year or for a total of 6 years. If a person's been with you for a year, then and they leave or you terminate them, then you actually have to keep them for 2 more years for a total of 3 years. Keep I-9 records separate from your personnel records. It's a lot easier if there's an audit and you need to find those I-9 documents. It's also a lot easier to purge them if you keep them in a file and say, well, this person's been gone. They've been gone for a year. I've had it for at least 3 years. Let me purge the I-9 document. Because face it, when ICE comes in and they want your documents and you give them documents that are 5, 10 years old for people that have been gone for a long time and there are mistakes on them, believe it or not, they can still fine you. So get rid of those old ones if you don't need to keep them. Now, what can you ask as an employer when someone comes in and says, well, let's say I don't want to do visa applications for my employees. I don't have the money. I don't have the time. I just don't want to do it. Can I discriminate against those folks? Well, you can. I mean, it's not discrimination. You can ask things like, are you employment authorized? Yes or no? And you can put this on your employment application. It doesn't tell you much. If they say, yes, I'm employment authorized, it could very well be that they're employment authorized, but maybe for someone else. And keep in mind, folks on visas, on work permits, those work permits are typically employer-specific and employment-specific. So if they change employer, chances are you got to do something for them to make them work authorized for you. Also, for instance, foreign students, after they graduate, can typically get a work permit for a year, up to 29 months, actually, if they have a STEM degree, science, technology, engineering, or math degree. So if they say, yes, I'm employment authorized, but 5 months from now, I'll need for you to get me an H-1B or whatever visa, then, suddenly, so that doesn't tell you much. So the next question is more important is, will you now or in the future require visa sponsorship? That means, will I have to do something to keep you employed? Me as an employer, petition for you, file paperwork with Immigration Service. If they say yes, you can say, well, thank you for applying, but you don't have to hire them. So those are things you can ask, and basically that's been said. It's okay to ask those things. Now that could change down the road, but at this point, it's legal to ask those questions. E-Verify, I do want to mention E-Verify because Georgia is an E-Verify state. If you have 11 or more employees, you're supposed to use E-Verify. Again, it's kind of a verification program. It's separate from the I-9. It doesn't take the place of the I-9. It's in conjunction with the I-9. It's available again through the USCIS website. If you sign up for it, then you have to have someone designated to deal with E-Verify. Again, it compares records from the employee, typically Social Security number, immigration status, or other status, and compares it and figures out whether or not that person standing in front of you is employment authorized, or whether there's a tentative non-confirmation, or they have to do something. And keep in mind, there's also an E-Verify self-check right now, where employees can actually go online and check their employment eligibility and make sure that there are no issues before they actually go look for a job. About 500,000 employers, using E-Verify, but a lot of states are requiring it. So it may become nationally mandated or a federal mandate where everybody has to use E-Verify or a similar program. E-Verify is also available in Spanish, by the way. Now, why E-Verify? It's because of the Georgia immigration law. It's back the Illegal Immigration Reform and Enforcement Act of 2011. It was called House Bill 87. And that basically Georgia required employers to use E-Verify. It was actually phased in based on the size of the employer. But right now, if you have 11 or more employees in Georgia, you're supposed to use E-Verify as of July 1st, 2013. So keep that in mind. I kind of want to round off the I-9 part of the webinar with my top I-9 compliance mistakes, my top 10, kind of like David Letterman does. Number 10, records not segregated from other personnel records. Why is that important? because sometimes the I-9 form shows where the person is from. And so it may taint the, if you keep it in their employee file, it may taint their file if they're fired and say, well, you fired me because I was Indian. Well, how do I know? Well, my I-9 was in my personnel record. So you know, do segregate them. It's also easier to get them if they're in one place and you have an ICE audit or someone wants to do an internal audit to make sure that the records are up to speed. So again, segregate them. Probably a good idea. Number 9, failure to monitor expiration dates. I mentioned the Section 3 re-verification. Keep that in mind. Have a tickler system so that if someone is expiring, you don't keep them on the payroll. They have to do something, bring you a new employment authorization document, or show that they're still work authorized. Number 8, mishandling of photocopying verification documents. I mentioned that copies are not, you don't have to make copies, but if you do, be consistent. If you're not consistent, then that's when you get in trouble and could get fined for, again, paperwork violations. Number 7, if you as an employer accept documents that are not genuine, fakes, frauds, again, don't sweat it too much. As long as they look real and you feel that they're real. If you want to check with someone else, say, does this look real? You could do that, but again, make sure they're not fakes. Number 6, same thing. Don't accept photocopies of verification documents. So the Social Security number, Social Security card, or driver's license, or work permit, or passport need to be originals. Don't accept copies. Number 5, failure to complete the Section 2 employer certification block. I've kind of highlighted it. It's on page 2 of the I-9 form, and it's where you fill out that, in fact, you verify these documents on that date. If you leave it blank, then immigration can't, or Immigration Customs Enforcement can't see that you did it timely. So make sure you fill that out. So many times I go to clients and look at their I-9s and see these same mistakes propping up. And again, it's not a big deal. A person may be a U.S. citizen even, but it shows that you're doing it right. And if you're sloppy, you could get fined for not filling out that little block. So do that. Number 4, over documentation. As I mentioned, it's list A or B and C, not A, B, and C. Sometimes I see people, really being zealous and, I want to fill out everything, and they got way too many documents. Again, that is called a paperwork violation and could actually result in a fine of $110 to $1,100 per I-9. If you have 5 people, okay, that's maybe not that much. If you have 1,000 people, that could be a big problem. Number 3, the employee fails to fill out that status block on page 1. What if they didn't fill it out? Can you fill it out as employer? No. You have to go back to them and say, wait a minute, you didn't check one of the 4 blocks. Please check it. And make sure when they check it that it's consistent with what else they said in their I-9. If they say, I'm a citizen of the United States, but yet they gave you a green card as a list A document, that's inconsistent. So make sure they complete it and that it's completed. Otherwise, again, it's a paperwork violation. Number 2, this is fairly new because now we have a 2-page I-9. The pages become separated. Again, on the top of page 2, there's actually a block to put the employee's name in there. Please do that in case they become separated. And I guess that could, cause some problems or some anxiety if they get separated. Number 1, drum roll. The number 1 top I-9 mistake is failure of the employee and or employer to sign and date the I-9 form in a timely fashion. That's always an issue. If it's not dated or not signed, it's not complete. If it's not complete, it could actually result in some fines. Let's talk briefly about the executive orders that President Obama announced in November. And some of these things could be helpful. There's parts of these executive orders may make life a little harder for you as an employer. Now, unfortunately, or fortunately, depending on where you look at it, there are 2 sections of that, and I'll talk about that, of these executive orders that could affect you immediately. And one was supposed to go into effect February 18. Other one was supposed to go into effect in May. On February 16, actually, a federal judge in Texas blocked the implementation of the executive order, especially DACA and DAPA, which we'll talk about. And right now it's in litigation. There's an injunction. The administration is asked to lift the injunction, and it's stuck. But stay tuned. There's obviously a lot more coming up about that. What are these executive actions? How do they affect you? There are two versions, or actually two parts of it. One is called DAPA. You may have heard DAPA. It's Deferred Action for Parental Accountability. That was the original title. I think they've titled it now Deferred Action for Parents of American Citizens or Legal Residents. And that's basically a program for unauthorized parents. People that came here, crossed the border illegally, had U.S. children. Of course, if a child is born in the U.S., they're automatically a U.S. child. And so, again, here on this, I'm not going to read this slide to you, but it kind of tells you what the qualifications are for DAPA. And again, it's not free. I was talking to an HR group last week and told them it's $465. I said, what? That's expensive. You know, what if they can't afford it? And the idea is that about 4 million people would be eligible for this DAPA. And what DAPA does, it keeps them from being deported just for an immigration violation. Obviously, if there are criminal problems or they're in trouble with the law, they can still get deported, still get removed. But if the only violation they have is they're here illegally, then it would keep them here. And the more important part is they could get an employment authorization. The EAD is the employment authorization document. Again, the forms aren't ready yet and can't be filed yet, but they would be ready in May, maybe later, depending on the lawsuit. And it's going to be $465 filing fee for that. Again, so you as an employer could suddenly find people that come in with an employment authorization document, assuming this DAPA goes forward. Then suddenly they're maybe coming in with a different name. Maybe they were Jane Doe and now they're Mary Brown. What does that mean as an employer? And we'll talk about it in a little bit because I want to first move to the expanded DACA. DACA has been around for a while, since 2012. That's Deferred Action for Childhood Arrivals. Again, the executive action expanded it a little bit. Now, the way DACA is now, you get those children who are eligible get a 2-year work permit, get deferred, meaning they don't get deported for just violating their status in the U.S. The new DACA or expanded DACA will be a 3-year work permit, again, still $465. And there has been the only change here, the age ceiling has been eliminated. In the past, you can only apply for DACA if you're under age of 31 on June 15, 2012, when DACA came into being. That age limit has been, or ceiling has been eliminated. So anybody can actually, if they qualify as DACA, even if they're over 31, can apply for this expanded DACA, assuming DACA goes into effect. At this point, again, it's still on hold. And I think about another couple of $100,000, 200,000 people would be eligible for this expanded DACA. Now, keep in mind, DACA and DAPA do not give you or give these persons immigration status. It's just a temporary relief from removal or deportation. It's not a green card or citizenship. They're not standing in line. It's not a path to citizenship. Also, as I mentioned, they're not available immediately, and quite a few people will be eligible, perhaps even 4, 5, 6 million people. And this could expand the legal workforce by about 4 million. What does that mean? These people may already be in your workforce, but suddenly come in and now are legal to work in the U.S. So what do you have to do then? If these people come in with a new date of birth or a new name, I would say, complete a new I-9. If you're subject to E-Verify, go through E-Verify as well. Now the question is, well, why should you do this? Well, most of the time these people, you like them, they're good employees, you want to keep them on the payroll, and then some employers say, well, what if I have an honesty policy in place? What if these employees, when they come to work for me, sign saying, everything I give you is true and correct, these documents are genuine, they belong to me, I am Jane Doe. What suddenly if they're not Jane Doe? Then you can go back to this honesty policy. Well, wait a minute. Violation of this honesty policy could mean termination, and I could let you go. The problem with that is you have to, if you have an honesty policy, you have to be, again, consistent in actually, complying with this honesty policy. If you say, well, I'm not going to enforce the honesty policy for all the Indian employees, but I'm going to enforce it for the Hispanic employees, you're obviously discriminating based on national origin, and you could get in trouble, serious trouble. So be consistent in your enforcement of your honesty policy. Again, if you have one, great. If you don't have one, you may want to look at one. And so that could happen. These people could come out of the shadows and say, oh, wait, I'm eligible for this work permit. I want to come out of the shadows and tell you who I am. Keep in mind that if they do that now, say, well, I'm going to get this work permit. Once the bell's been rung and they say, I'm not really authorized to work, but I'll get one in 3 months, you can't keep them on the payroll because then you know that these people aren't authorized to work in the U.S. Again, it's pretty confusing. The I-9 is already confusing. And even though the Handbook for Employers doesn't clear up the confusion, about 70 pages, it's confusing. With DACA and DAPA, it's going to be even more confusing. These people come in and say, hey, I've changed my name. Now what? Hopefully there'll be more guidance as these programs come into being. Maybe a new employer handbook, an I-9 employer handbook, maybe a new I-9, who knows? You could face liability as an employer for past hiring of unauthorized workers or for discriminating against folks that bring in new work authorization. So it's pretty scary out there at this point. So wait for guidance. That's the bottom line. It's not available yet. It could be this summer, it could be later, who knows, depending on the litigation, obviously. Keep in mind, it's still unlawful to hire undocumented workers, and doing so, again, will still be resulting in penalties. And I've talked about paperwork violations, which are fairly minor as far as a fine, $110 to $1,100. Unknowing violations are much more expensive. Could be $3,300, could be even $10,000 or more. Could subject you to criminal penalties, means jail time. So be careful in filling out this I-9. What about the executive order? Is that kind of a beginning of immigration reform? Probably not. Unfortunately, I'm an optimist. I'm an immigrant myself. I came over a long time ago, got a green card, became a citizen, and so I kind of seen it on the other side of the coin. And I know I'm an optimist that things will change, but immigration reform is probably not going to happen anytime soon. One of the things that as immigration practitioners we always look for is, let's streamline it. Let's make it a little more user-friendly. The thing we're dealing with currently is the H-1B visa. It's a special occupation visa, which has a cap on it, and you got to file it by April 1st for an October 1 start date. And then they're only 85,000 available, but there'll be more than 200,000 filed probably in that first week in April. And then they'll have a lottery. Immigration will have a lottery. If you're not picked, your file gets sent back. You don't get even processed. If you get picked, then you'll get processed. And it's kind of scary. Now, as a nonprofit, if you're affiliated with an institution of higher education, you're not subject to the cap, which is good. If you're not affiliated with an institution of higher education, you're still subject to the cap, and you may have to file for H-1Bs by April 1 for an October 1 start date. So that's pretty much all I have about I-9. What you're supposed to do, make sure that you do it. If you have any questions, please let me know. I'm available for questions. Yes. Yes, the question was, can I describe an H-1B visa? An H-1B visa is a very useful tool for employers hiring typically foreign students who just graduate. Let's say they graduate from Georgia Tech with a degree in engineering. They can require, or they can actually ask for an employment authorization document to work for a period of time after they graduate. They have to work, they can't just sit around, but it's not based on any particular employer. If an employer finds someone with this employment authorization document, likes them, and wants to hire them, they then have to go the next step. They then have to go file this H-1B. It's also referred to as a specialty occupation visa. It requires as a minimum a bachelor's degree to fill the position, and of course the person you're hiring has to have a bachelor's degree as well in a related field. It could be a foreign degree. Sometimes you could do equivalencies, and the visa is valid for 3 years. It's kind of a strict visa. It's really employer specific, employment specific, location specific. You have to do prevailing wage. Make sure you pay the person this prevailing wage. And that prevailing wage has to be hung up in the employment space for 10 days. So you show that you're hiring someone as an H-1B and you're going to pay them this prevailing wage. Sometimes that causes some friction with other employees and say, wait, they're paying this, because they know pretty much who they're talking about. So they're getting paid $10,000 more than me. That's not right. So obviously there are some things you have to do to get the H-1B. Unfortunately, since it's not always available, you got to plan ahead of time. A lot of times I have folks coming to me in May or June and say, well, I find this young man or young woman, a bright graduate from a university here. I want to file for an H-1B. At that point, typically you're out of H-1Bs. The cap is not applicable to hiring H-1Bs away from someone else. If someone comes to you and says, I have an H-1B for company A and you're company B, and I want to hire you, I can hire you away from company A, and there's no cap problem. You can file the H-1B anytime, but you have to file it. The new employer has to file it and has to start from scratch for the H-1B. It's a useful tool, valid for 3 years, can be extended once for an additional 3 years, for a total of 6 years. And the idea is that within those 6 years, you start working on a green card, which is a more permanent permit to work in the U.S. and remain in the U.S. Much more complicated. Green cards, you have to deal with the Department of Labor. You have to test the market, show that you're not taking jobs away from U.S. workers, and it gets pretty expensive. And typically, this is what we do every day. It's always good to have an employer, deal with their attorney that specializes in that field, because again, so many little things can go wrong. As you could tell, little boxes could be checked wrongly, and then things could get denied, and time is money. They'll send it back to you, have to redo it, and it takes a lot longer. On the other hand, if you're from India and China, it takes a very long time to get green cards, to get permanent residence, because there's a limit per country every year. For instance, every year there's a limit of 140,000 green cards based on employment every year for the whole world. Per country, you have a limitation of, I think it's about 7%. So you have less than 10,000 per country. Well, there are a lot of Chinese citizens who want green cards, a lot of Indian citizens who want green cards, so they get backlogged. I would say if all you can require is a bachelor's degree for an Indian citizen, they're going to be waiting 20, maybe 30 years on a green card. Now, if you can require a bachelor's degree plus 5 years of experience or a master's degree, then sometimes things go a little quicker. They may be available, or the wait list may be a lot shorter. But again, it takes a long time. A lot of advanced planning is required.
The second question is, you talked about ICE coming in and doing an audit. Can you talk to us about how that might happen and what it does?
The question was about ICE audits, Immigration and Customs Enforcement, and doing audits and coming in and trying to check your records. How are those I-9 audits done? Well, typically it's targeted. They're typically looking for large employers with a blue-collar workforce, people manufacturing, where perhaps there could be a lot of Hispanic workers. Sometimes it's also targeted because someone complained within the company and said, hey, so-and-so is here illegally. They call ICE and say, come check it out. Now, ICE doesn't have time to run down all those tips, but if the company is large enough or there have been previous violations, it's entirely possible that you're targeted by ICE. Keep in mind, if ICE comes in, you have 3 days to give them your I-9s. They'll say, well, give me all your I-9s and your payroll records and whatever, and they'll ask for a bunch of stuff. I say, well, I'll give you my I-9s, but nothing else. Well, they can come back with a subpoena and get everything else possible and shut you down for a while. So cooperate to a certain extent, but use those 3 days to, number one, call your attorney, make sure your I-9s are in order, and I would suggest to at least yearly, or maybe more often, do a little internal audit. Make sure that your I-9s are in good shape, that you can find them all, that you have I-9s for all employees there, so that in case the ICE officer comes in and audits you, you're ready. No pressure, no stress. You have them there. They've been reviewed. Again, take your full 3 days to make sure they're in order, and then submit them to ICE. I've been involved in those audits before. They look for discrepancies. They look for people that are not authorized to work. Obviously, they have a record of people that are authorized to work or not authorized to work. They can come back and say, hey, here are 10 workers that are not authorized to work. You got to terminate them. If they say terminate, you better terminate them. Also, they could say, well, we've checked your I-9s and they're okay, but there's some systemic errors. Please verify or correct those. Sometimes you get your one bite at the apple where you can actually correct them. And they say, okay, good, you corrected them. We're not going to fine you. If you're a habitual violator, meaning this has happened before, you're kind of sloppy with your I-9s, they could still fine you, and those fines could again run up pretty severely, depending on the size of your workforce. But be ready for those. Now, obviously you have to have I-9 audits and ICE people available to do that. They're going to target larger employers more than likely, or they're going to target employers where their complaints have come to their attention. If you're pretty small and again you do what you're supposed to do, don't worry too much about an I-9 audit at this point. Okay, great. And it's good to kind of every so often, again, review your records, make sure you're using the right form. If you want to make corrections, you can make corrections, but make sure if you do make that correction to initial the correction and date the correction, the date you make that correction. Don't backdate stuff. Again, that could get you in trouble as well. So I would say, just keep it. It's important. It's something you have to do, and it's unfortunately when you hire someone, you have to do that.
More about segregating the I-9 from personnel files. If we have I-9 in with personnel files, should we not go back to the special files?
It's a good question. The question was, tell me more about segregating the I-9 records from personnel files. If I haven't done that in the past, can I now do that and segregate them? And yes, absolutely. Again, it's not a legal requirement to separate those, but as I mentioned, a couple of things come to mind that could help you if those things are actually segregated in a separate file. One is an I-9 audit, obviously. Then you don't have to go through every personnel file, pull out the I-9s. But if you can't find it, what if the personnel file is thick? Keep them in a separate file. Also, as I mentioned earlier, the taint of national origin discrimination. If that I-9 is kept in the personnel file is then used to discipline the employee, perhaps even terminate the employee, and the employee can come back and say, well, you fired me because I was, Indian. Well, no, this is because of your performance. Well, no, the I-9 was in my personnel file, and so you know that I'm Indian because I gave you a green card, and I said I was born in India. If you keep that file, that I-9 file, separate, or the I-9 information separate, and there's nothing in that personnel file that says you're Indian. So I certainly did not terminate you because you were Indian. I terminated you because you were not performing. So that's important as well. If now you want to actually pull the I-9s out of the personnel files, do it. Put them in a separate file. Put them chronologically, time-wise. Also, make sure that if you copied I-9 documents, that they're attached to the I-9. Don't separate them now. Put them in a separate file. Also, that file will help you. And I would do two files. One, current I-9s, and I would put another file where people were terminated. Put them in there, and then every so often, maybe 3 or 6 months, take out the ones you can discard because they've been had been gone for a year after termination, and it's been 3 years, or they're old and gone, and so you could get rid of those as well. So I would keep 2 files, one active employees and one, recently terminated employees, and then figure out every so often which ones you can discard. To me is good, a good thing to do. Also, sometimes in that same vein, people ask questions about, okay, I heard you about not making copies of I-9 documents. What if I now want to institute that policy? I know I've always made copies. Do I go ahead and tear all the copies off the I-9s? No, don't do that. Those are part of the I-9. Now you could say, well, as of today, as of March 18, 2015, my policy is not to make copies anymore. And that's fine. Again, it's a lot easier to be consistent. But then the ones that have copies, keep them in there. And these people, as they leave, obviously they'll be terminated or they'll leave, and those I-9 forms will be purged down the road. But good idea. Again, you don't have to make copies. If you do it, that's fine. I guess bottom line really is, if you do it correctly and you try to do it right, don't fret too much whether you make copies or don't make copies. Just be consistent. That's an excellent question. The question was, do I e-verify someone who was hired before e-verify was implemented? And the question is, the answer is absolutely no. E-verify is for new employees. You can't e-verify folks that you've hired in the past, and now you want to e-verify everybody. It's only for new employees. Also, you cannot e-verify someone before they start working for you, because, what if you have some tentative non-confirmation, so, well, I don't want to hire you. No, e-verify is in conjunction with the I-9 for new employees, unless you have a federal contract. If you're, under a federal contract, of course, then you have to e-verify everyone that's working on that federal contract. Probably not likely to happen for you, but if you do, keep that in mind as well. But e-verify is only prospective, so do not go back to. Also, e-verify actually, shows you when you have to do it. If you don't do it timely, then you have an issue in e-verify. Well, I waited too long, to e-verify this person. Why did you wait so long? What's the reason? So if you now find out that, let's say maybe the question was, okay, I know that e-verify, I have 15 employees. I've had 15 employees since July 2013. I suddenly realized I have to do e-verify because of this seminar. Can I e-verify folks now? Absolutely, you can e-verify them, but if you do that, I would say if you don't do it, well, you're not in compliance. If you do it now, the problem is, well, you're doing it after hire. What do I do then? Can you put in your little e-verify block, did it late? I'm sorry, because it'll kick you out. If it's a late e-verification, it'll kick you out, and the system will tell you this is beyond the time. So be careful. I would say at this point, I would only e-verify new employees. Don't go back. If you made a mistake, that's, I would think you just put something in the file saying, realize that, but I can't e-verify past employees, so, don't do it. Okay. Great. Well, thank you. This webinar will be available on the Pro Bono Atlanta website.